Hi there, I'm Jenna Leyton, the Vice President of Legislation for San Diego SHRM, and today I'm bringing you your quarterly employment law and legislation update. Let's start by taking a look at what's new in legislation. Governor Jerry Brown has signed into law Senate Bill 292, a bill that amends the Fair Employment and Housing Act to specify that sexually harassing conduct need not be motivated by sexual desire. The new law overturns the case entitled Kelly v. Conoco Companies, wherein the California Court of Appeal held that a sexual harassment claim must be based on conduct that shows that the perpetrator is acting based on sexual desire or intent, or is motivated by the victim's actual or perceived sexual orientation. Governor Brown has also signed into law Assembly Bill 11, a bill that amends the Labor Code to permit an employee who performs emergency duty as a volunteer firefighter, reserve peace officer, or emergency rescue personnel to take a temporary leave of absence not to exceed an aggregate of 14 days per calendar year for the purpose of engaging in fire, law enforcement, or emergency rescue training. Qualified employees who are discriminated against in connection with such leave are entitled to reinstatement and reimbursement for lost wages. The new law takes effect on January 1st of 2014 and applies to employers with 50 or more employees. Finally, Governor Brown has signed into law Senate Bill 462, a law that amends Section 218.5 of the Labor Code with respect to the award of attorney's fees in wage and hour cases. Under previous law, either an employee or an employer could seek recovery of attorney's fees and costs as the prevailing party in an action brought for the non-payment of wages, fringe benefits, or health and welfare pension fund contributions. The new law makes the award of attorney's fees and costs to the employer contingent on a finding by the court that the employee brought the action in bad faith, even where the employer is the prevailing party. Let's now move from legislation to the judiciary and take a look at some of the case rulings that may affect your business. In Mendiola v. CPS Security Solutions, a California Court of Appeal addressed the complexities of compensable time under California law in determining an employer's duty to compensate its on-call employees. The court held that on-call time is considered compensable when an employer exercises sufficient control over its employees. However, the court also protected the right of employers to contractually agree to deduct sleep time when certain requirements are satisfied. CPS Security Systems, CPS Construction Protection Security Plus, and Construction Protective Services, collectively CPS, offer security guard staffing for building construction job sites throughout the state. CPS provides its security services 18 hours per day, Monday through Friday, and 24 hours per day on Saturday and Sunday. In order to satisfy its security coverage schedule, CPS requires its guards to remain on job sites for the entirety of each 16 or 24-hour shift. During the 16-hour weekday shifts, guards are on duty from 5 o'clock a.m. to 7 o'clock a.m., and again from 3 o'clock p.m. to 9 o'clock p.m. Between 7 o'clock a.m. and 3 o'clock p.m., they are free to come and go as they please. During the 24-hour weekend shifts, guards are on duty from 5 o'clock a.m. to 9 o'clock p.m. For both the 18 and 24-hour shifts, guards are required to remain on call between 9 o'clock p.m. and 5 o'clock a.m. While on call, guards are required to handle any issues which arise on the job site, but are also provided with fully furnished trailers wherein they are permitted to sleep, bathe, and relax during any time not spent attending to work-related tasks. Guards are not permitted to have pets or child guests in the trailers, and adult guests are only permitted with prior approval. While on call, guards may not leave the premises without express permission from CPS, and when such permission is granted, guards may travel no farther than 30 minutes away. During that time, guards are required to wear a pager, which can be used to call for an immediate return to the job site. Guards are only compensated for time spent handling on-site issues. The remainder of their on-call time is unpaid. A group of guards, collectively the plaintiffs, filed a class action suit seeking damages for failure to pay wages during the on-call periods and for declaratory relief regarding the legality of the on-call employment provision. The trial court ruled in favor of the plaintiffs, finding that on-call time amounted to hours worked under California law. CPS appealed the decision. Under California law, employers are required to compensate employees for time during which employees are subject to the control of the employer. A number of factors are considered whereby a determination is made regarding the level of control exerted by the employer. In this case, the appellate court held that during the on-call periods of the 16-hour shift, the control exerted by CPS over plaintiffs substantially restricted their actions and therefore warranted compensation. With regard to the 24-hour shifts, however, the appellate court cited past precedent to find that CPS may still deduct 8 hours of sleep time from the guard's compensation given the satisfaction of certain requirements. The court instructed that a sleep time provision may be enforceable when it has been formalized in writing and provides that the employee, number 1, works a 24-hour period, number 2, is provided adequate sleeping facilities, and number 3, receives an opportunity to sleep for at least 5 uninterrupted hours. Here, CPS and the plaintiffs entered into an agreement which satisfied these requirements. CPS was therefore permitted to deduct 8 hours of sleep time per 24-hour shift. The court's ruling serves as a good reminder that when an employee is on call and therefore subject to employer control, he or she is entitled to compensation. However, when circumstances necessitate an employee remaining on the job site for an entire 24-hour period, employers may seek contractual provisions permitting sleep time deductions. A California Court of Appeal held in Beaumont-Jacques v. Farmers Group that a former district manager of a group of affiliated insurers was an independent contractor based on the appointment agreement she signed with the group, as well as the type of discretion she exercised in her daily job duties, her ability to hire and supervise her staff, and her identification as self-employed on her personal tax returns. Appellant Aaron Beaumont-Jacques, also known as Appellant, worked for several years for a group of affiliated insurers. In September of 2005, she became one of their district managers by executing a district manager appointment agreement. The appointment agreement specifically provided that there was no employer-employee relationship. In her new role, Appellant recruited and recommended persons to become insurance agents solely for the signatory defendants and regularly exercised an increased level of autonomous discretion in her regular tasks. She also recruited, trained, and motivated individual agents who sold insurance products for the signatory defendants and had autonomy with respect to the hiring and firing of her own office staff and set her own day-to-day hours, including vacations and arrival and departure times. In October of 2009, Appellant voluntarily terminated the employment relationship, receiving nearly $200,000 from the signatory defendants pursuant to the appointment agreement. In May of 2010, Appellant filed a suit against various defendants, including the signatory defendants and Travelers Group, which collectively will be referred to as respondents, asserting claims for breach of contract, sex discrimination, and unfair business practices. Respondents filed a motion for summary judgment, which the trial court granted, finding that respondents did not exercise sufficient control over Appellant in order to convert the relationship into an employee-employer relationship, and that Appellant retains sufficient discretion in the performance of her duties and in the manner in which she performed them for her to be deemed an independent contractor as a matter of law. The trial court further ruled that because Appellant was an independent contractor, none of her claims could be maintained against respondents. In examining the trial court's ruling, the Court of Appeal found the type, as opposed to the level, of discretion regularly employed by Appellant in the completion of her duties and job performance goals indicated independent contractor status. While Appellant argued the fact that respondents set goals for her employment and the existence of various other indicia unrelated to the control over her job duties were indicative of an employment agreement, the Court of Appeal upheld the trial court's ruling in its entirety. This case highlights the very thin line California law draws between independent contractors and employees. The key question for California courts is generally whether the individual has the right to control the manner and means of accomplishing the result desired. The existence of the right to control, rather than the amount of control, is important. Employers should review their classification policies to ensure that individuals are appropriately classified in light of the relevant factors. Finally, in Alamo versus Professional Management Information Corporation, the California Court of Appeal ruled that while the mixed motive defense is valid, it is only available when an employer raises the defense in its initial pleadings. The plaintiff, Lorena Alamo, first joined Practice Management Information Corporation, or PMIC, as a collections clerk in 2006. On January 15th of 2009, Alamo began a pregnancy-related leave of absence. Her baby was born approximately 2 weeks later. On February 18, 2009, Alamo requested an additional 6 weeks of maternity leave to bond with her baby, which was granted by PMIC. Alamo was scheduled to return to work on April 22, 2009. While Alamo was on leave, PMIC hired temporary employees to handle her duties. According to PMIC, the temporary employees and management quickly discovered major failings in Alamo's performance, which she had been able to conceal while actively working. While PMIC had known Alamo had some minor deficiencies and personality conflicts with coworkers, these had been viewed as insufficient to warrant discipline. However, in light of the newly discovered performance errors, the performance issues previously known, and a disputed incident in which Alamo went to PMIC's offices during her leave and engaged in an altercation with coworkers, PMIC discharged Alamo in April 2009. After the discharge, Alamo sued PMIC for wrongful termination and pregnancy discrimination. Following a trial on the merits, the trial court ruled in favor of Alamo. PMIC appealed, but the California Court of Appeal affirmed the ruling. PMIC thereafter appealed to the California Supreme Court, which withheld any action on the case pending its decision in the case of Harris v. City of Santa Monica. As you may recall, in March of 2013, the California Supreme Court ruled in the Harris case that a plaintiff bringing a discrimination claim under the Fair Employment and Housing Act must show a discriminatory motive was a substantial factor in the relevant employment decision, not merely a motivating factor. This decision allows employers to avoid a complete loss at trial when the facts indicate that an employment decision was based primarily on non-discriminatory grounds, even if some minimal element of discrimination existed. A successful mixed motive defense precludes an award of monetary damages to the plaintiff, but courts are still empowered to award attorney's fees, injunctive relief, and declaratory relief. After ruling on the Harris case, the California Supreme Court vacated the appellate court's decision in Alamo and remanded the case for further review under the new Harris standard. PMIC and many observers believed that this would result in a defense verdict, as the facts appear to support the now valid mixed motive defense. However, the appellate court took a surprising approach and ruled that because PMIC had not specifically raised the mixed motive defense in its initial pleadings, that defense was unavailable at trial. According to the court, PMIC's failure to initially plead the defense constituted a waiver of the defense, which could not be resurrected at a later stage of the proceedings. Accordingly, the appellate court again ruled in favor of Alamo, despite affirming the validity of both the substantial factor standard and the mixed motive defense. The lessons from Alamo are twofold. First, the mixed motive defense is alive and well in California and should continue to provide a strong liability shield for employers in discrimination cases. Second, employers seeking to avail themselves of the mixed motive defense must assert the defense in their initial pleadings. Failure to plead the defense at the outset of a case will result in a waiver of the defense, irrevocably eliminating one of the best protections available to defendant employers. Working with experienced counsel can help employers ensure that this and other critical defenses are effectively preserved and utilized. The cases I just mentioned are just a sampling of recent judicial decisions that affect California's employers. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please contact me at 858-509-5696. You can also contact me via email at jlayton@pettitcone.com. That's all for this quarter's legal update. Thanks for tuning in.